that. Good morning, I'm Robin Shapiro. I'm the board chair of HealthAdvocateX, and we're delighted to welcome you to another community conversation. I'd like to just acknowledge that this community conversation is supported by getcopayhelp.com, which is a platform that helps patient advocates easily discover and enroll patients in prescription financial assistance. For more information, please visit getcopayhelp.com, and they will also be featured in our e-newsletter if you would like more information. So with that, I would like to welcome our speaker, Aaron Engle, who is an attorney, and he's going to be talking today about how to get financial assistance. And with that, I'd like to turn it over to Aaron. Thank you. Welcome.
Hey, thanks, Robin. And thanks everybody for being here today. I know this is it's a big topic, and I'm going to try to cover as much as I can here in 20, 30 minutes. But obviously, disability benefits are a big deal for people who are dealing with a chronic medical condition and can't work. And it can be a very confusing process, and unfortunately can take a significant amount of time to get benefits approved. So what I'm hoping to do here today is kind of help those folks get on claim a little quicker and more efficiently, and hopefully they don't need to use the services of somebody like myself. So a little bit about me. I kind of do appeals and litigation of denied long-term disability claims, as well as short-term disability claims. Those typically are insurance-based. Sometimes they're self-funded plans. For some employers have big, self-funded plans where it's not an insurance product. And I don't do Social Security claims, but because Social Security disability interacts pretty significantly with long-term disability claims, I do know quite a bit about how the process works. If you really want an in-depth discussion of Social Security disability, there's a lot of good resources on socialsecurity.gov, and I would really encourage anybody who has somebody that's stuck in the Social Security disability process to get an experienced Social Security disability attorney, because they are very burdensome and confusing. So, with that, let's kind of jump into it. So really, when somebody, if they come to you or they're dealing with a chronic medical condition and they reach the point where they're medical providers and they don't think they can work any longer, the initial options available for them are, there's going to be really 4 or 5 things. So one would be, a lot of employers provide a short-term disability policy. Now, typically those are insured by, like Hartford, MetLife, Prudential, and they typically are going to cover 3 to 6 months of disability. They will have a 1-week waiting period, sometimes 2-week waiting period. And that's, called the elimination period typically. And that's going to be a period of time where the person has to be disabled, but they're not going to get paid for that period. Generally, an employer provided short-term disability policy is going to be own occupation. And I put in the chat, and we're going to talk more about this later when it comes to long-term disability, kind of a typical definition of own occupation. And so what that means is basically they have to prove that they're disabled from their own job. And that's going to be their own job as it's defined in the national economy, not necessarily how it's performed at their specific employer.
Is there a big difference? I'm going to be asking you questions throughout.
Yeah, so there can be a big difference. So for example, think about somebody that works at Amazon, that is, a really rigorous employer, and not just for blue collar workers, but for white collar workers as well. Where the expectation for performance could be very high. and the demands by the specific employer could be very high. But what the insurance company is going to look at is like, how is that? What's the job description and how is that defined in the national economy?
Hmm.
So not necessarily as uh, performed by the specific employer, which could be more difficult. So the basics of the short-term disability application is really kind of four-part. There's going to be a form for the employee to fill out that kind of describes their medical condition, symptoms, medications, what they can and can't do, activities of daily living, a little bit about their background, training, education, experience, um, that kind of thing. There will be a form for the physician who's supporting disability to fill out. Those are typically called an attending physician statement. Um, there will be an authorization for the claims or plan administrator to get medical records. And then there'll be a form that goes to the employer that kind of talks about the job, the data hire, the rate of pay, all that kind of stuff. So when somebody applies for short-term disability, and this is, equally true for long-term disability, the employer is going to be aware because there's a part of the form that they have to fill out. So then once the paperwork gets into the claims administrator, then there's going to be an interview. And this is normal, happens in every case. And the interview is going to track basically the forms themselves. And just think of it as the claims handler is just trying to get to know the person and why they can't work. A lot of people are, nervous about this, of course, and but really the interview generally tracks the forms. And there is always a little bit of pushback from the claim administrator of like, why can't you work? You've been working through this for a while. What changed? And so it's good to prepare somebody for that kind of conversation. So that's a short-term disability policy that's offered by an employer. Many people have those. If they don't have that, then the other option is a self-funded short-term disability plan. And these are kind of more like payroll practices. So, big companies around here in the Seattle area that have a self-funded plan, or Microsoft, for example. And those will have a claims administrator because the employer obviously is not in a position to evaluate whether somebody's disabled. And that claims administrator is usually an insurance company. So like a Hartford or Prudential, they not only do insurance, but they do claims administration. And the one thing that confuses people about a self-funded plan is that there will also be paperwork for the leave of absence from work. So for FMLA leave, and that's often the same entity that is evaluating the eligibility for disability benefits under a self-funded plan. But the two processes are different. So somebody can have an approved FMLA leave and a disability claim that maybe doesn't get approved. The application process for a self-funded plan is the same as what we just went through.
And
The one,
is it different from state to state, or is it a national kind of universal?
yeah, so the self-funded plans will be different, not necessarily by state, but by
By
employer.
plan? Oh, okay.
Yeah, so the employer, so sometimes self-funded plans could have additional requirements beyond proving the disability. They might have like a requirement that you had a positive performance review in the last year, or
Mm.
um, things like that, right? Or have been working a certain amount of time. Usually a short-term disability plan, you're going to be eligible. So non-self-funded, like a policy, you're going to be eligible as soon as you're employed or within 30 days. But self-funded plans can have employer-specific requirements. The definition of disability is usually similar, its own occupation, and that's what the person has to prove that they can't do. The big difference between a self-funded plan is it's not an insurance claim.
Mm-hmm.
So it's not governed by, state insurance laws. And it's kind of a discretionary, they describe them as discretionary payroll practices. So it's more of an employment law claim if it gets denied, which is not really a discussion we have time for here, but it is relevant. And um, as long as you focus on why the person can't do their own job, then you're going to be all right for the most part. But it does change the governing law, like the appeal rights.
Mhm.
And we'll talk about that in a second. The other option is a private short-term disability policy. Those are very uncommon. I don't typically see many of those. First off, most people don't have a private disability policy. It's typically professionals, dentists, doctors, CPAs, that type of, but most employees are not going to have a private policy, yet alone a short-term policy.
So it's more for like self-employed people.
Yeah,
Yeah.
and I'm going to not go into a private short-term disability policy because
Mhm.
we'll talk about private long-term disability policies, and everything I say for those will be applicable to a short-term policy if somebody were to have one for 3 to 6 months. The other thing that's available to a lot of folks is a state-run paid family medical leave program. I put a link in the chat for basically a good source for various states. Um, in Washington, for example, we have a mandatory paid family medical leave program. It pays up to 12 weeks of benefits. The application is to the state. Um, and the max benefit is a weekly benefit about $14.27 a week. And really how much you get from that program really depends on, what you were making before. It does have an eligibility requirement. You have to have 820 hours of work. But it's a good option for people with a short-term disability. And they can go to the Washington Paid Family Medical Leave site, and it has all the application materials. And like I said, there's I believe 13 states, and DC has a mandatory paid family medical leave. And if you check out the link, you'll see if your state is one of those. And it also has information on the eligibility requirements. Um, so if somebody doesn't have any of those things, then really the only option for a short-term disability is sick days, vacation days. Some employers have a shared leave program. That's typically like governmental entities. But those are the initial options available for folks. And, the important thing to remember, no matter the program, it's best if somebody gets their application in, as soon as possible. 30 to 45 days is, kind of a good way to think about it. And these things don't get better with time, and an application and the delay that's kind of built in the process, can be burdensome. So it's better if people get started sooner rather than later. And many short-term and long-term disability policies will have proof of loss provisions, which define how quickly the application should be in. And you don't want to run afoul of those. So the next step, and hopefully the claim is approved, and we'll talk a little more about that. But if it's not approved, then for a employer provided policy or self-funded plan, there's going to be an appeal deadline, and it's going to be typically 180 days. And that is a hard and fast deadline. People have to make that. If you don't make that, then basically the claim is more or less over.
Hmm.
Reviews of these claims generally take 45 to 90 days. It's not unusual for them to take longer than that. So that is a point of stress for people, obviously. And that's why you want to get the application as soon as you can, because even if you get it in a timely fashion, it's still going to take some time. One of the other things to keep in mind that also makes that process confusing applying for short-term disability is that if there's a short-term disability policy and a self-funded plan, either one, they're going to require the person to apply for any state benefits. And so here in Washington, the program has kind of in some ways made short-term disability policies sort of obsolete, because the policy will require you to apply for Washington paid family medical leave. When you get Washington paid family medical leave, it is a dollar for dollar offset from what the insurance policy has to pay. So, for example, if somebody is going to get $2,000 a month from their short-term disability policy and they get $1,000 a week from Washington paid family medical leave, they're really going to get zero or a minimum benefit from the short-term disability policy. And those minimum benefits are typically $100 or 10% of what the benefit was going to be. And so in some ways, you have to apply for these two things and you're only going to get one, So that confuses people, but I almost never see a short-term disability policy or a self-funded plan that doesn't require you to apply for governmental benefits and doesn't make it an offset.
Huh. Interesting. So are there people that apply just for the state benefits and don't bother with the short-term plans? Or is
Yeah, I
there
would
any
not
strategy
recommend.
for that?
Yeah, I would not recommend that. Yeah, I mean, you just have to realize that the short-term disability policy, if you're in a state with a governmental program, is just really not going to pay you very much. But you would want your short-term disability claim to be approved, because if your disability is going to last longer than 3 to 6 months, you would want a smoother transition to long-term disability.
Mm-hmm.
And so, that's what we'll talk about now, which is, really the big sort of ticket thing, which is the vast majority of people have a employer provided group long-term disability policy. And some people have a self-funded long-term disability policy, but very few employers are big enough to self-fund a long-term disability. But when I do see it, it's somebody like AT&T or Comcast, Time Warner. But most, FedEx is another example. Most people have an insurance policy that's a group policy provided by the employer. And they either paid some of the premiums or the employer paid all the premiums or a combination.
Mm-hmm.
The thing that's different about these cases is they're governed by a federal law called ERISA, which is the Employee Retirement Income Security Act, passed in Congress from 1974. It governs all employee benefits. And unless the person works for a religious institution that has not elected to be ERISA governed, or works for a governmental entity, the case is going to be governed by ERISA. And it changes pretty much everything everybody's accustomed to when it comes to civil cases. There's no punitive damages, there's no extra contractual relief. The only remedies available for an improper denial are restoration of the claim and past due benefits. There's no jury trial. There's no discovery. There's no cross-examination. There's no witness testimony. It's really just an administrative review by a federal judge of the claim file. Somebody asked, ERISA applies, no, ERISA applies to any employer. So that's
Doesn't matter how big.
non-governmental.
Doesn't matter how big.
Or
Doesn't matter how
religious.
big.
Size doesn't matter.
Mm.
So for example, I'm a small company, have 3 employees. Our disability policy is governed by ERISA. ERISA creates an administrative process for handling the claims. And the elimination period for most group provided long-term disability policies is anywhere from 30 to 180 days. It's generally correlates to the short-term disability policy if it's been offered. But if there is no short-term disability policy, then usually for the 0 to 6 months, that's how long somebody's not going to be paid, but they still have to prove they're disabled during that period. If somebody transitions from short-term disability to long-term disability, there's going to just be the whole application process again. Similar to the short-term disability, 4-part. And another interview that tracks the forms. And a lot of people are like, don't you know everything about my claim already? You were the short-term disability company. Oftentimes it's the same company, but the reality is it's just a whole new process.
Why don't they share information? Just
So they will share information.
Mhm.
Oftentimes, like the file will get kicked over, so they will know something about it. But the process is different because the potential exposure on a long-term disability claim is much greater. So they're going to do their own review.
Mhm.
Because long-term disability policies, typically cover people until they reach retirement age, either 65 or whatever their Social Security retirement age is. So so there'll be that same 4-part application, and we're going to talk about ways to help get the claim approved. But just don't, if you're helping people, just explain to them this whole new application process is normal if they're going from short term to long term. The most important thing to remember about an ERISA claim is that if it's denied, they will be entitled to a copy of the claim file as it stands.
The patient will.
Yeah, the
Yeah.
insured, the patient insured.
Okay.
And it's really important to get that if the claim is denied because you need to see what was done by the insurance company to deny the claim. And they have to provide that to them if they deny the claim. The other big thing to remember is that you have 180 days to appeal that denial. That's hard and fast. If you don't appeal in the 180 days, basically the case is over. The only thing that matters is the claim file. Think of it this way. There's a cardboard box with your client insured patient's name on it. Everything that they submit is in it. Everything the insurance company puts together is in it. Everything the physicians have sent in is in it. If the claim is denied, you're entitled to a copy of it. When we do appeals, I review the claim file and I say, okay, what's missing? What needs to be done? How do we prove this claim? Because the appeal period is the only time to prove the case. When you do an appeal, hopefully they approve the appeal and start the claim. But if they don't, if they deny the appeal, then that cardboard box is like taped up. And if the person files a lawsuit, it gets shipped to a federal judge and we argue about the contents. There's no opportunity to present witnesses or very sometimes, but just think of it as that cardboard box is what the judge is going to review.
So I have
If
a couple of questions also about that cardboard box, virtual or physical. Is it difficult to get the file to the patient or the advocate? Like, does it take time? Like medical records, sometimes they draw out or they put in barriers in terms of having to pay to photocopy. Are those things that generally advocates will have to, or families will have to fight for?
so, the claims administrator has to send you the claim file free of charge.
Mhm.
There is delays. It has to be a written request, technically. That can be an email from the patient or a letter. It's generally better if it's a certified mail letter, of course. They should get the claim file in a matter of weeks, but oftentimes, even when I'm getting them, it takes 2 or 3 requests. Generally, it varies by insurance company, but typically they're going to send either an electronic version or like a share file link of it. Some carriers still send a paper box. I get like a 10-pound box of paper.
And
Um,
if their delay basically shortens your 180-day window to examine those contents. There's no like extension or anything else available.
You can always ask for an extension, and sometimes they give them, and that does happen to me occasionally where I will ask an extension. But even when I get an extension, I get it in writing, and I do my damnedest to get an appeal in by the 180 days.
Mhm.
Just because the last thing you want is them to say the appeal was untimely. But there's really no penalties for improper claims handling in ERISA. This is a pretty complicated discussion, but in Washington, we get de novo review, which means the judge just reviews the file and makes his or her own decision as to whether the person's disabled or not. But in many states and many circuit courts, really the biggest penalty for improper claims handling is a move from abuse of discretion review to de novo review. So in some states, the judge is going to evaluate whether the insurance company has a reasonable basis for their decision with some maybe conflict of interest analysis. They can lose that deferential review, the insurance company, if they make errors in the claims handling process. But that's really kind of a whole hour conversation in
Okay.
itself.
Yeah.
But the thing to keep in mind, get a denial, entitled to the claim file. Get a denial, 180 days to appeal. During the appeal, the only thing, that's it. That's when you prove the case. And everything has to be in writing and submitted to the insurance company. The other thing about a ERISA case is that's different than is kind of boggles most people is there's no treating physician rule. So the insurance company does not have to give deference to the treating physician.
What
They
does that
will,
mean?
so they will hire record reviewing physicians, or they will hire physicians to review the evidence. Those people will make their decision as to whether or not the person is disabled. And the insurance company doesn't have to defer to the treating physician. They don't have to give the treating physician any more credit than those record reviewers. So which is a little different than Social Security. Social Security gives deference to the treating physicians,
Hmm.
um, which is um, which is good because obviously those folks know the patient the best. But in an ERISA case, the Supreme Court has said many times that there's no treating physician rules, so they do not have to follow what the treating physician says.
Wow.
So for a employer provided policy, usually the definition of disability for the first 24 months, sometimes this can be 12 months, sometimes it could be 36, but most of the time it's 24. The patient has to prove that they're disabled from their own occupation, which is a similar definition to the short-term disability. Um, After 24 months, the definition of disability is going to change to any occupation. And hopefully that any occupation definition has an income qualifier to it. And we're going to talk a little bit more about this. The other thing to keep in mind with most employer provided group disability policies is that they're going to have a limitation for mental health conditions to 24 months. So it only provides coverage for 24 months. For substance abuse is another very common one, 24 months. And unfortunately, more disability carriers are writing into other limitations. So a very common one that I see is fibromyalgia, chronic fatigue syndrome, viral infections, which is obviously a big deal right now with long COVID. Many of those claims can be limited to 24 months.
So, and can the employer, so the person is not going to be getting benefits beyond that? And does that also bleed into the employer's ability to terminate that employee?
Yeah, so the disability determination is not usually tied to the employer situation. So
Okay.
remember, there's one track where somebody's on leave with
Right.
their employer, and there's another track where they're applying for disability benefits. Obviously, if a long-term disability claim is approved for any length of time, it's usually going to exhaust, especially a long-term disability claim. By the time that they reach that long-term disability eligibility, they will have most likely exhausted their protected leave. And
Mm.
so they will be on an unpaid leave status. It really varies by employer as to how long somebody will be on unpaid leave. But eventually, if the person cannot be accommodated, they've exhausted their FMLA leave,
Mhm.
uh, they're going to be separated from employment. The separation from employment doesn't impact the disability claim because the disability claim commenced prior to termination. So, they can at some point people are going to be on both, and then they're going to be separated from employment and they're going to be on disability. So, the last thing I would say about group policies that's you be on the lookout for is, like I said, the person should get a copy of the policy, uh, and they should have it because that's the rule book. And the thing they want to look for is a definition of disability, and is how long are they going to be covered for their condition. And the other thing that comes up often is long-term disability policies will have a pre-existing condition clause. So unless the person's been working and covered by that policy for a year, then they're going to not cover a pre-existing condition. Um, so the other option that you might come across is people might have a group policy, but they might also have an individual policy, an individual privately purchased disability policy, that they may purchase with their own money. And, those are often occupation specific. So like, um, or their own occupation policies for life. Obviously, those are the best. Um, but there can be 24-month owned to any occupation definitions as well. Um, and the application process is the same, burden of proof is the same, all of that. The only difference is that it's governed by state law. So if you have a private policy here in Washington, it's governed by Washington state law, which is far more protective than ERISA. There's a lot more remedies for improper claims handling. You can sue for bad faith, triple damages, and but the claims process is largely the same. Um, and many times those people might have both, but that's somewhat unusual. Then the other benefits that are available to people obviously are Social Security disability claims. So, I don't practice in Social Security disability, but obviously, in order to have a Social Security disability claim, you have to have paid into Social Security, generally over your work life. You're going to have enough quarters in the last, I think it's 4 to 5 years, that you've paid in. There are some employers and some employees that don't pay into Social Security, and so they would not be eligible. Um, the definition of disability for Social Security is the inability to do any gainful activity. So it's closer to like an any occupation definition. Um, it's a long process to get. The application is burdensome. And it feels like some of them are just denied carte blanche, many of them, honestly. And then the second stage is called reconsideration. And then the third stage, if that's denied, you go before an ALJ, administrative law judge. And then beyond that, there's appeals counsel. Um, so I really recommend that somebody get a competent Social Security disability attorney um, once they've applied and been denied.
And is that
And
something that's easy to find? Like if somebody wants to find that type of
yeah,
attorney?
most there's a lot of Social Security disability attorneys. I generally I have referrals that I like, but Yeah, it's not too hard to find a Social Security disability attorney. Obviously, they're not all created equal. And many times the long-term disability policies will refer people to these vendors for Social Security disability assistance. And the reason for that is because the long-term disability company wants them to get Social Security because it's a dollar
So
for
they
dollar
don't have to.
offset.
Yeah. Mm.
But yeah, I mean, trial lawyer websites and bar association referral lines would be a good source for, kind of Social Security attorneys that have been vetted. Um, with Social Security disability, age is a factor. For somebody who's 58 to 62, it's going to be easier to get Social Security than somebody in their 20s or 30s. Certain medical conditions can meet a listing. The one people know of quite a lot is like statutory blindness, for example, but there's a whole 12 categories of listings. Um, and getting one of those, you just kind of have to follow the template for each listing. And that's why a Social Security attorney can be helpful. But for each listing, as an advocate or a physician, you can kind of see what they are and what the person has to prove. Then the only other really option for a long-term disability, somebody who's out of work for a long time is SSI, Social Security income. That's really not an option for people with any kind of assets. So that's really only available to people who have little to no assets. Like common resources like vehicles and monies and bank accounts can
They all count.
disqualify.
Yeah.
Yeah. So
Mm.
I believe it's 2,000 for individuals and 3,000 for couples. So, it's not really a viable option
Yeah.
for most people.
Yeah.
So let's talk about the burden of proof and understanding the definition of disability. So the first thing to remember is that the burden of proving that they're disabled is on the insured. Okay. Nobody else has to prove it. They have to prove it. Um,
Yikes.
so a lot of people apply and think that the insurance company or the administrator is going to help them prove it, and that's not going to happen. The insurance company or the claims administrator is going to review what the physician send, what the insured, the patient sends, but the burden to prove that they meet the definition of disability is on them. And that's just the way it is. They got to be able to prove they can't be a competitive and predictable worker. Usually, like we talked about, from their own job for the first 24 to 30 months. And the insurance company just has to do a full and fair review. Now, oftentimes they don't. Obviously, I'm somewhat jaded when it comes to that. But their obligation is to do a full and fair, reasonable review, but they don't have to go out of their way to help prove the case, and they won't. Um,
Could you give us maybe two side by side examples of somebody who's done that burden of proof well and what you've seen in terms of somebody who's not done the burden of proof well? Because that seems to be kind of like a pivotal thing that people on this call may need to understand in more depth.
yeah, absolutely. So take a look at that definition of disability. So I've just kind of given a typical one. Disability or disabled means you're prevented from performing one or more of the essential duties of your occupation during the elimination period and your occupation for the 24 months following the elimination period. And the result, your currently monthly earnings are less than 80% of your index pre-disability earnings. So there's two parts. One, you have to have a 20% income loss. Usually that's pretty easy to prove. But if somebody's working part-time, that might require like pay stubs and things like that.
Mm-hmm.
The key part is the essential duties. So essential duties means a duty that is substantial, not incidental. It's fundamental or inherent to the occupation and cannot be reasonably omitted or changed. And so the formula for getting disability claims approved is like this. My patient has XYZ conditions
Mhm.
causing ABC symptoms, which makes them unable to do one, two, three, four of their job. That last step is the most important. I always tell people diagnosis doesn't mean disability. Um, there's no such thing as permanent disability. You're always going to have to prove you meet the definition of disability. And how you do that is by focusing, at this initial stage on what it is you can't do at your job. So, um,
At your own job for
at
short
your
term
own
and then
job.
in general after the 24 months.
Yeah, so if
Okay.
you look at that any occupation definition, it means
Yeah.
any occupation for which you're qualified by education, training, or experience that has an earnings potential of 80% or more of what you're making.
Hmm.
So what I see a lot of medical providers make a mistake is they will say, my patient has multiple sclerosis, has these symptoms, therefore she's disabled. And they don't talk about why it is the person can't do their job. And part of it is many medical providers are, they're kind of reticent to help because they think that disability means invalidity, or, the person can't do any work, or they can't ever do any work, or that the condition is permanent. And that's not true. These should really be called income protection policies. That's what you're protecting.
Hmm.
And so specific examples of what you can't do at your job. So the patient can't sit for 4 hours or more, can't maintain focus on a screen all day and look at Excel sheets, loses concentration, can't focus in meetings, um, you know, has chronic pain, so is always shifting positions, can't sit and stand for long enough. Um, you know, to really be specific about the parts of their job that they cannot do. And as a patient advocate, that might require getting their job description and kind of going through it with them and talking about, can you do these things? And why can't you do them? And that is what needs to be in both the patient's, um, you know, explanation to the insurance company and both what the treating provider who's supporting the claim says about the person.
So
So
get that into the medical record, basically.
yeah, well,
Yeah.
medical records were never intended to prove a disability case, of
Yeah.
course, and they were never really intended for much other than justify billings, and so the person can remember what they talked about last time. But they don't talk about why the person can't do their job. So a lot of times when I see claim files, there's really no discussion, and part of the reason is because the treating provider believes the person has a history with them and maybe doesn't document like all the things they can't do at their job. So a lot of times what we end up having to do is having people evaluated by physical capacity examiners, um, sent to neuropsychologists, um, get testing that objectifies their limitations, their restrictions and limitations.
Hmm.
Um, have a vocational person talk about why they can't be accommodated. So these can be things like, unpredictable, like take a migraine person, the unpredictability of it, um, the fact that they're going to have absences maybe once a week. Um, all of those are reasons why somebody couldn't do their own job or any job really. Um, and so those are things to focus on.
You said something very interesting previously, which was some employers require, maybe in short-term disability policies, that you prove that you've had a positive review within a year. And I'm thinking that that might be a very difficult bar for many people to achieve. So, like, how common is that?
Yeah, it's not terribly common.
Okay.
Yeah. Um, but what I always recommend is that people just don't assume that they're covered by their short-term disability or their self-funded plan. They should always get a copy of it
Hmm.
and review it,
Hmm.
just so they know, what they're up against.
Hmm.
Because, yeah, it's those are the rule books, and
Hmm.
has everything you need to know to prove a claim.
Hmm.
Um, disability companies are looking for something acute. So, this is a big problem for people who deal with chronic medical conditions. They usually tough it out as long as they can. And, you know, the pushback that they get is like, well, you were able to work with your MS for 3 years or your Parkinson's. What changed? You know? And, the reality is most people just burn out, and it just gets to be too much. And there's like this subtle sort of falling off of their work performance. And then their physician says, look, you just can't do it anymore. Let's apply for disability. Um, so one of the things I recommend when people apply is considering providing your own medical records for the past like 4 to 6 months. The insurance company, when they order them, they're really going to order them from the last day to work forward, which might not tell the whole story of somebody's medical progression of how they've been fighting and fighting and they just crashed.
Hmm.
Um, also recommend that people provide their own medical records with the application, because that is a big source of delay for insurance companies. As everybody knows, getting medical records is somewhat, it's the one thing that would make me want to quit what I do. Uh, honestly.
Well, and advocates and people who are involved in health advocacy, that's a huge discussion point. Always keeping a personal health record.
Yeah. And so sending medical records in, I recommend. I also recommend, statements from family, friends talking about why the person can't work anymore.
So you can
Uh,
submit that.
yeah. Remember, it's the insured patient burden to prove. The
Mm.
insurance company has to review what you send. They, of course, are not going to really give much deference to statements from like somebody's spouse or brother or sister, but those can be supportive, and talk about why the person can't work anymore.
Hmm.
Um, again, objectifying as best you can the subjective reporting through functional capacity testing, neuropsych testing, not
So,
feeling constrained by the forms that they send. The forms that they send are often not specific to the person's medical condition. So I always encourage medical providers to write a letter that talks about why it is they can't work using the formula, specific things that the person can't do it in a workplace. Talk about their patient validity, their treatment compliance, all those things. Because at the end of the day, a lot of these cases just come down to the insurance company doesn't believe you and doesn't believe your
right.
doctors.
Yeah, yeah. I'm curious, and we didn't talk about this in, I don't think we talked about this in speaker prep, but is there any, discrimination according to people's ethnic backgrounds, anything like that, that you could shed any light on? Is that a whole area? Like, is there racial bias or anything like that that people should be aware of and address?
Yeah. Yeah.
Oh, maybe that's sorry that I
Yeah.
just thought of that because I was like,
I I
that's
I would think that in like most areas of American life, there is racial discrimination. So, I mean, I have not really done any data studies on it. My sort of anecdotal feeling is that there is discrimination. Uh, I would say there's a lot of gender discrimination. Um, um, I would say that there is, yeah, I would
so
say there
so
is.
so say more about that gender discrimination, like people don't believe women's pain as much as men, that type of thing.
Absolutely. Yeah. Mhm. Yeah, that would be a big one. Chronic fatigue, rheumatological conditions, fibromyalgia. There's definitely a bias against women that their chronic pain is not legit. Um, Yeah.
Interesting.
And
I
so the
could,
way to combat that is with the statements from family and friends, um, performance reviews from the past saying this person was doing a great job in work, um, their CV resume that shows a work history, um, you know, neuropsych testing that has validity measures embedded in it that, that the examiner can say, hey, this person gave 100% honest effort on the testing,
so
which a lot.
what does that mean? I don't understand that.
So neuropsych testing and physical capacity testing, they'll have validity measures embedded in them so that the examiners can say that the person gave a full and honest effort. And a lot of times that data is important because it buttresses the person's subjective reporting. Um, of course, there's no test for chronic pain. There's no test for, chronic fatigue, really. I mean, you can do some testing
Mhm.
for chronic fatigue. Um, but a lot of it comes down to, do they believe the patient's reporting? And if you have some objective evidence showing that the person's been gave a valid effort on neuropsych or physical capacity testing, has been compliant with their treatment protocol, regimen, medication compliance, so doing everything they can to work and to stay healthy,
Mhm.
that supports their subjective reporting. So all that kind of, any evidence that does shows that is helpful.
Mhm. And I want to just say for the people who are tuning in, if you have any questions, please put it in the chat. This I can't believe this almost hour has gone by. We only have a few minutes left. I guess another question would be, in your experience in all of these domains, what are some of the most surprising things that patient advocates might not have a lot of exposure to a whole lot of patients in the disability claims arena. So, what are some things that might be surprising other than the burden of proof, which sounds very surprising?
Yeah, so I think the big thing is that the surprising thing is that most medical providers are afraid to get into this process to
Mm,
help. So more and more, we're getting difficulty with treating providers being willing to assist with the disability claims process. And one of the things that one of the things that I try to explain to treating physicians is that if it's ERISA governed, you're not going to be hauled into trial. There's not going to be discovery. There's not going to be witness testimony. The second thing is put the definition of disability in front of them. And most of these physicians probably have a disability policy themselves, privately purchased, that just covers them for their own job. And to remind them that you don't have to prove invalidity. You don't have to prove this person, that definition I showed you, you are prevented performing one or more of the essential duties. So if the patient can't do two or three of the essential duties and they've had the income loss, then they're disabled. You don't have to prove invalidity or that they're going to be unable to do activities of daily living. Most physicians, what was surprising to me as I've been doing this, is they just go straight to that.
mhm, mhm. We have a question from Ali DeGroot. If you don't feel this is related to after a claim has been opened, if you feel that the physician has not sufficiently proven inability to do job duties, is it okay to submit your own written description saying such, or better to have an appointment with the physician to specifically focus on that document? What do you suggest?
Yeah.
Question.
So I would meet with the physician and, perhaps give them the definition of disability and the job duties.
Mm-hmm.
And oftentimes, you know, the big trouble, of course, is helping people with disability claims is uncompensated time for physicians for the most part. And so, that's another reason why they're not too happy about it. Um,
So they can't code the physician visit to get reimbursed for the
I'm not
time.
an expert on that, but my hunch is that the answer is no. And,
Okay.
oftentimes people have to make an appointment with their physician, and part of what the main purpose of the visit is to go over the disability forms. Um, but yeah, I generally recommend trying to work with the physicians to understand what it is the burden of proof.
Hmm.
And once they understand that, then they're better at writing a letter. And the other thing, as I said, those forms are not designed for whatever the condition is. So I really encourage people to say see attached and write a narrative.
So
Both
give give
insured.
them give them the words and the framework to consider.
Yeah, a lot of times, like for like a MS patient, there'll be this form of like how much can you push, pull, sit, blah, blah, blah. And it's like designed for an orthopedic injury, like if somebody has a hip, you
Yeah.
know. But it's in this for the worst place for this is like mild TBI cases, right? Where there'll just be this physical restriction form. And it's not at all applicable to somebody that has a mild TBI.
Right. Yeah.
And then sometimes they send if they don't send that form, then they send a behavioral health form and try to make a mild TBI into like a mental health condition. So
Yeah.
both the insured and the physicians really encourage them not to be constrained by the forms,
Uh,
to
uh, yeah.
put attachments that really talks about why it is they can't work.
Great advice. And we're so grateful for you in sharing your experience. This has been it was a really fast hour, and I feel like we could have gone a lot longer. So, your bio and information is up on our website. So, if other people have follow-up questions, you know how to reach Aaron Engle. Thank you so, so much. And I just wanted to say again, grateful for the support of getcopayhelp.com, who is supporting this particular community conversation. We want to remind everybody that we have three really great events coming up in the next couple of weeks. October 24th is our networking event, talking amongst advocates about the unspoken fears of advocates, spookiness around the Halloween theme. On November 11th, next month's community conversation is about the difficult patient label and how that affects care. And then November 13th, we're kicking off our next X Center, which is trauma informed care. We have 5 sessions and a live panel discussion. And Madeline very kindly, oh, and thank you, Aaron, for putting your contact information in the chat. Madeline has put the registration links in there, but you can also find it on our website at healthadvocatex.org. Thanks so much, everybody, and have a great week.
Thanks, everybody.
Bye. Thanks.